Hi, everyone. Welcome. Thank you all for joining us today for our International Solidarity for Palestine Lessons from Law and Labor webinar. My name is Greer Brabazon, and I'm a member of ACEP-CAPE for Palestine, which is a group of members of the Canadian Association of Professional Employees organizing in solidarity with Palestine within our Federal Public Service Union. I'm so pleased to be moderating today's panel with our incredible guests in collaboration with Labor for Palestine, which is a national network of labor activists across Canada who stand in solidarity with the struggle of Palestinian workers and people. ACEP-CAPE for Palestine is one of Labor for Palestine's growing number of union groups and city-based chapters that are fighting for Palestinian liberation, not just within a labor movement context, but by examining the ways in which our own labor intersects directly and indirectly with processes and products that uphold Israel's occupation of Palestine. We are very pleased to share that in part through our efforts, ACEP-CAPE, as one of the third largest federal public service unions, released a ceasefire statement with a list of demands for our government, who's also our employer. So I would encourage you to check it out on the website and to like and comment if you can, your support on ACEP-CAPE's social media posts announcing that statement. To date, it's one of the most well-liked and commented posts, so let's make sure to keep that going. I am joining you today as well as a settler on the unceded and unsurrendered traditional territory of the Algonquin and Anishinaabe. Particularly as a union of federal public servants, we are very mindful of our role and responsibilities as we work on Indigenous lands and as we embark on Palestinian solidarity organizing while operating within and contributing to the very systems of oppression, settler colonialism, and imperialism that we aim to fight against. So as you reach out to your local Labor for Palestine chapters, which I encourage you to do, as you start your own member-driven group in your local or national union, which I also really encourage you to do, and as you please join us online and in the streets. You can find both groups on Instagram at Labor for Palestine. That's labor with a U and then the number 4, Palestine. And then ACEP-CAPE for Palestine. That's ACEP-CAPE 4, the number 4, Palestine. So as you're doing all of these wonderful things, we just ask that you remain cognizant and respectful of whose land you are on and remain dedicated to supporting Indigenous land back actions and activities in your own communities. So we're going to jump in. Since I know you're not here to listen to me, I want to begin with a huge thank you to our panelists today, South Africa's High Commissioner to Canada, Rieaz Moe Shaik, former UN Special Rapporteur and Professor Emeritus of Law, Michael Lynk, and Labor Professor, Dr. Katherine Nastovski, who have all very graciously offered their time and expertise today as we dive into the lessons we can learn from South Africa's apartheid from both a legal and labor perspective, and what our important next steps need to be as we utilize the developing legal and labor circumstances today to continue advocating so fiercely for a free Palestine. So our panelists will speak each for 10 to 15 minutes, which will be followed by a question and answer period. So we encourage you to share your questions in the question and answer box at the bottom of the screen throughout the presentations. And I would just like to thank all of the registrants who provided questions early through the webinar registration form. All right. So I am so honored to introduce our first panelist today, High Commissioner Moe Shaik. He assumed the role of South Africa's High Commissioner Designate in Ottawa in 2022. His career has spanned various important roles within the South African government, as well as representing South Africa in foreign posts around the world. He has a regular presence in Canadian media, providing commentary on South Africa and global affairs. He's the author of ANC Bible, Surviving Across Enemy Lines, which is a fascinating account of his life and anti-apartheid activism prior to becoming an official in the South African government. So thank you so much, High Commissioner, for joining us today. We are so grateful for your perspective on these issues.
Thank you. I'm sure you can hear me. If not, you'll indicate. I thank the Labour for Palestine movement and the Canadian Association of Professional Employees for organizing this webinar. A few weeks have passed since the historic ruling of the ICJ, which allows us to reflect on the development of this matter, especially on the important topic of lessons from law and labor. It has now come to be in the records of international jurisprudence that South Africa has successfully argued before the World Court that Israel's war against the Palestinian people may constitute genocide. Further, in terms of the Genocide Convention, the World Court has placed the obligation on Israel as a signatory to that convention to prevent genocidal conduct in its war against the Palestinian people. As a result of South Africa's actions, many commentators, both elsewhere in the world and here in Canada, have with unmasked contempt labeled South Africa's case as legally absurd, ludicrous, and/or meritless. As history would recall, the highest court of the world, the ICJ, by its injunction given on the 26th of January 2024, has established beyond all doubt, by a near unanimous ruling, that the charge brought by South Africa against Israel was legally sound, rational, and justified. Further, in a recent civil case brought by the US court by the Center of Constitutional Rights in the matter referred to as Palestine versus Biden, the presiding judge referred extensively to the ICJ's judgment. The presiding judge in this matter also found that it's a plausible case of genocide perpetuated by Israel and wrote in his ruling that the evidence led before the court supporting the plausible case of genocide was incontrovertible. I have raised these two rulings of the court as a demand of those who preach to the world about the need to respect the rule of law to practice what they preach. The binding ruling of the ICJ that Israel is engaged in a plausible case of genocide against the Palestinian people is now a ruling of the highest court in the world. The World Court has spoken loud and clear. In this sense, the charge that plausible genocide may be occurring as a result of Israel's military conduct is no longer only the charge of South Africa. It is now the judgment of the court. Accordingly, the world community is called upon to respect the judgment of the ICJ. The acceptance of the ICJ's ruling must form an integral part of our collective understanding of what constitutes the respect for the rule of law. It matters not whether we agree with the judgment or not. It matters only that there is a judgment of the court that must be respected. This, after all, is the basic tenet of democracy. Simply put, the respect for the rule of law must mean the respect, both in word and action, of the interim judgment of the ICJ. As Democrats, we are required to act in accordance with the declaration of the judgment. As we all know, the judgment of the ICJ is binding on Israel, as it is on all signatories to the convention. To do otherwise is to disrespect the rule of law, to perpetuate a hypocritical approach to the rule of law, and is nothing else but a demand to act with impunity against the rule of law. The respect of the rule of law is for everyone. It is a demand that is made to the most powerful amongst us, that the rules of war are governed by the rule of law. The respect for the rule of law is a comfort to the most vulnerable amongst us in their most desperate time of suffering, that holds the promise that the rule of law has not abandoned them. The respect for the rule of law is a clarion call to awaken the silent amongst us, to find our voice, and to speak out against war crimes, crimes of genocide, and the violations of human rights. The respect for the rule of law demands of those that are complicit in the crime of genocide, either by acts of commission or omission, to correct their ways and to stand firm behind the respect for the rule of law. In the aftermath of the ICJ binding provisional measures ruling, a few other inappropriate comments were made that requires a response. Contrary to what Israel claims, South Africa is not the legal arm of Hamas. We are the moral voice of the oppressed people of Palestine, calling out for the killing to stop and to give peace a chance. In so doing, we make clear that we do not speak on behalf of the Palestinian people as their authoritative voice. To do so would be unbecoming of us as South Africans and would perpetuate the false belief that the question of the Palestinian people can be solved without Palestinian voices. Far from it. However, we do make clear that we as South Africans speak of the plight of the Palestinian people. We speak against the inhumanity perpetuated against Palestinians by Israel and her allies. We speak up for the right of Palestinians to live their lives in freedom from the tyranny of a plausible genocidal war. We speak up for the rights of the Palestinians to be given the opportunity to exercise their right to self-determination. In so doing, what we have done, we claim no moral or righteous superiority, nor do we make a servile apology for what we have done. We have acted in the way we have simply because this defines who we are. Through our lived experience from apartheid to democracy, we have come to value the human rights of all people. We value the right of all people to live in freedom from fear and want. We value our strong conviction to negotiations as a means to end all conflicts. We reject cultural and racial prejudices, especially as a form of governance. We reject the right of any state or people to act with impunity and without consequence. We condemn the support given to Israel by her allies that allows Israel to act with impunity in her pursuit of plausible genocide. On 11th February 1990, almost exactly 34 years ago to the date that we gather here, Nelson Mandela, the great icon of South Africa's liberation struggle, was released from 27 years of incarceration by an apartheid state. Perhaps it is fitting that on an occasion such as this, we reflect on Nelson Mandela's approach to the question of the Palestinian people's struggle to be free. In 1997, while still president of a free, democratic South Africa, he said, "We know all too well that our freedom is incomplete without the freedom of the Palestinians." Further, Mr. Mandela was a strong advocate for the self-determination of the Palestinian people, for the human rights of the Palestinian people, and for a two-state solution to this conflict. Mr. Nelson Mandela made his views clear at every opportunity he had to do so, and was strong in his belief for peaceful settlement of the Palestinian-Israel conflict. I raised the views of Mr. Mandela on Palestine because recently, a few Canadians have used their position of influence, giving themselves the authority to speak on behalf of Nelson Mandela. They have argued in the most opportunistic of ways to say that Mandela would not have supported South Africa's case before the ICJ. As a representative of the South African government, it is unimaginable for me to think that Mr. Mandela would have done anything else but support South Africa's case to the hilt before the ICJ. I go further to state, without any fear of contradiction, that Nelson Mandela would have been proud of South Africa's approach. To speak on behalf of great leaders such as Nelson Mandela, who have passed on in a manner inconsistent to their declared beliefs is to be disrespectful to the legacies and the lessons that such leaders have bequeathed onto the living. It's important that we have come together today to discuss the lessons of law from law and labor. Because despite the ruling of the ICJ that places a legal obligation on Israel and on others to prevent genocide, Israel's genocidal military actions continue unabated with impunity. With each passing day, the line between plausible genocide and actual genocide becomes more blurred. Since the ICJ's ruling, many more thousands of Palestinian civilians have been killed, millions have been forcibly displaced from their homes, and starvation and famine have come to define the conditions of human life in Gaza. Needless to say, all of this is in direct violation of the ICJ's ruling. Accordingly, today, on the 13th of February, South Africa has made an urgent request to the ICJ to consider whether the decision announced by Israel to extend its military operations in Rafah requires the International Court of Justice uses its power to prevent further imminent breaches of the rights of Palestinians in Gaza. We are requesting on an urgent basis the intervention of the ICJ to prevent Israel from any further destruction of Rafah, the last refuge for surviving people in Gaza. We are saddened that Israel's genocidal actions, live-streamed into the homes of millions around the world, continues with the unwavering support of Israel's allies, drawn almost exclusively from Western countries who profess to respect the rule of law. Never before in the history of the modern world has a country acted with such impunity. Never before has allies of such a country allowed it and empowered Israel to act with such impunity. Further, as a reminder to all, the ICJ in its ruling placed an obligation on Israel to ensure the supply of humanitarian aid to the people of Gaza. Accordingly, in my opinion, those signatories to the convention who have withdrawn their humanitarian support to the people of Gaza based on yet unproven allegations are acting in direct violation of the ICJ's ruling. All of this begs that we must ask the question to all those whose uncritical support of Israel stands in direct contradiction to their own professed values. What is it in the Palestinian people that causes you to believe that they are not part of the world's shared humanity, worthy of your protection and worthy of your support? Is it your belief that Palestinians are the children of a lesser God? Is it a narcissistic belief in your civilizational superiority that allows you not to practice what you preach? Is it a deep felt belief that despite the incontrovertible evidence to the contrary, Israel can do no wrong? Please do tell us. The world awaits your honesty. Thank you.
Thank you so much, very much. It's incredible how deeply impactful this ICJ ruling is going to be. So thank you so much for outlining all of that for us and reminding us that it doesn't just apply to Israel, it applies to every country and all of us. Thank you so much. Next up, I'm so pleased to introduce Professor Michael Lynk. Michael Lynk is a Professor Emeritus of Law at Western University in London, Ontario, where he taught labor law, constitutional law, and human rights between 1999 and 2022. Previously, he had worked as a labor lawyer in Toronto and Ottawa for a decade, and he's currently a labor arbitrator with the Ontario Grievance Settlement Board. In 2016, Professor Lynk was appointed by the United Nations Human Rights Council as the 7th Special Rapporteur for the human rights situation in the occupied Palestinian territories. During his 6 years as Special Rapporteur, he regularly addressed the United Nations Human Rights Council in Geneva and the Third Committee of the United Nations General Assembly in New York. His UN reports have been widely cited. He has frequently spoken to the UN, academic and institutional conferences in North America, Europe, and the Middle East, and he regularly publishes opinion pieces on the role of international law regarding the Israeli occupation of the Palestinian territory. So thank you so much, Michael. I really appreciate your time.
Greer, thank you very much for having me. It's an honor to be on this panel. You've mentioned that I teach and live in London, Ontario. I want to acknowledge the historical fact that the land that I'm speaking to you from is located on the traditional lands of the Anishinaabe, the Haudenosaunee, and the Attawandaron peoples, and that the neighboring 3 Indigenous nations to London and to Middlesex County, the Chippewa of the Thames First Nations, the Oneida Nation of the Thames, and the Munsee Delaware Nation, who all continue to live as sovereign nations with individual and unique languages, cultures, and customs. I'm going to speak in the time allotted to me today on the ruling itself. Let's remember that this had to do with the question of genocide. This comes from the 1948 Genocide Convention adopted by the United Nations General Assembly, of which I think there are now 153 states across the world that have signed on to it. Let's keep in mind that genocide is commonly thought of as the crime of crimes. It is, and the definition of genocide is defined, and I'll try to reduce the legalese with respect to this, but it's any of the following acts that are committed with the intent to destroy in whole or in part a national, ethnical, religious, or racial group, such as killing members of the group, causing serious bodily or mental harm to the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, or imposing measures intended to prevent births within the group. South Africa brought its application at the very end of December 2023 to the International Court of Justice, which is based in The Hague, and it's the highest court in the UN system. The 84-page application that was brought is replete with facts, with arguments in a very accessible way. It's an extraordinary piece of legal advocacy that nevertheless anybody can wind up reading. I still think, even though it's now about 6 weeks old, it stands as the best single compilation of what's been going on in Gaza over the last 4 months. In its arguments in front of the court, what South Africa was seeking was what are called provisional measures. We would know them in Canada as an injunction, that were meant to stop what it said were plausible violations of the Genocide Convention until such time, probably in a couple of years from now, that a full trial in front of the International Court of Justice can be held as to whether or not Israel has actually breached the Genocide Convention. So what South Africa had to prove was, on the basis of the existence of potential genocidal acts and potential genocidal intention, whether or not there was a plausible case that Israel had breached some or all of those definitions I've read to you that are contained at the heart of the Genocide Convention. So in terms of acts, what South Africa argued were the extraordinary number of deaths that had been caused by the Israeli military actions in Gaza since the beginning of the war, the extraordinary number of people injured. Right now, today, actually, it stands at about 28,500 Palestinian deaths, without counting the estimated 5,000 to 7,000 Palestinians who have died and are buried beneath the rubble of buildings that haven't been yet evacuated. Around 68,000 Palestinians who have been injured or wounded in the course of the war. The immense destruction to the civilian infrastructure in Gaza, flattening of over 360,000, damaging or destroying over 360,000 Palestinian housing units, flattening all 4 universities in Gaza, flattening many, many schools, 183 mosques, 3 churches, parliament buildings, courthouses, archives, all of them have wound up being destroyed. Those who've been to Gaza in the last few weeks describe the landscape as being lunar in appearance. So all of this, in terms of destroying the ability to wind up living as a people there, as well as the enormous death toll and injury toll, did persuade the court that there could well be genocidal acts that have been committed by Israel. It noted, in terms of the UN officials that it quoted the Undersecretary of Humanitarian Affairs for the United Nations as saying that Gaza has become a place of death and despair for children, no food, no water, no school, nothing but the terrifying sounds of war day in and day out. And also saying Gaza has since become uninhabitable. It also quoted the World Health Organization as saying that an unprecedented 93% of the population of Gaza is facing crisis levels of hunger with insufficient food and high levels of malnutrition. It's estimated today that that there are around 940,000 Palestinians over the 2.2 or 2.3 million Palestinians who live there that are at phase 4 of the starvation index that's maintained by international humanitarian groups. And there are about 380,000 Palestinians who are at phase 5, which is the catastrophic level of starvation. And there is no phase 6 in their calculations. So all of this led the court to say that there is a catastrophic humanitarian situation in the Gaza Strip that is at serious risk of deteriorating further until the court reaches its final judgment a couple years from now. So that's genocidal acts. The court also had to establish whether or not there was plausible evidence of genocidal intent. South Africa provided about 35 quotations in its application in December, coming from senior Israeli political and military leaders, which arguably indicated a genocidal intent with respect to the entire civilian population of Palestinians living in Gaza. The court relied upon 3 of those from the president of Israel, from the Minister of Defense of Israel, and from the now Minister of Foreign Affairs of Israel. The now Minister of Foreign Affairs, Israel Katz, said in a tweet on X in October, "We will fight the terrorist organization and destroy it. All the civilian population in Gaza is ordered to leave immediately. They will win. We will win. They will not receive a drop of water or a single battery until they leave the world." So implicit in the court's decision, which was measured but damning in my view, was the critical weakness that's at the very core of Israel's argument. It had no persuasive evidence to be able to bring back and counter to what South Africa had said with respect to the indiscriminate death and destruction that was going on has been going on in Gaza over the last 4 months. So the court ordered a number of provisional measures. The 3 really important ones are that Israel had to take all measures within its power to prevent the commissions of acts within the scope of the Genocide Convention. In other words, Israel could not breach in any way what is demanded by the definition of genocide in the convention. Number 2, Israel had to take all steps within its power to prevent and punish the direct and public incitement within Israeli society to commit genocide. And thirdly, Israel was ordered to take immediate and effective measures to enable the provision of immediately needed basic services and humanitarian assistance into Gaza. As well, the court called upon Hamas and other armed groups to immediately and unconditionally release the remaining Israeli hostages that they are detaining. As the South African High Commissioner mentioned, these are authoritative orders and they are legally binding. And they were ordered by an overwhelming majority of the court, either by a 15-2 vote or a 16-1 vote. What was missing, as many of us would know by now, in the provisional measures ordered by the court was any order for an immediate ceasefire. This, in my view, is a hole at the heart of the ICJ ruling. South Africa, I think, correctly argued immediately after the ruling was given that it is impossible for Israel to obey the provisional measures it was directed to follow, except through a humanitarian ceasefire. And we can see this with respect to the number of trucks entering into Gaza, trying to bring aid each day because of the intensity of the fighting now in the very southern end of Gaza, which is where at least 1.5 or 1.6 million Palestinians are now huddling, trying to have shelter from the war. There were only, let's see, on February 11th, 2 days ago, only 45 humanitarian trucks with humanitarian aid entered into Gaza. Keep in mind that before October 7th, there were 500 trucks a day carrying humanitarian aid going into Gaza. And that was when the need for humanitarian assistance was much, much smaller than it is today. So what has been the reaction with respect to the order? We've now almost 3 weeks after this has the International Court of Justice has come down with its decision. At the time when the court issued its ruling on the 26th of January, there were roughly around 25,000 Palestinians had died. We're now surpassing 28,000. So the death toll continues at the same level. The destruction as well winds up continuing. This ruling, I think, and Katherine will be able to expand upon this, has badly damaged, I think, Israel's reputation in the world, but has also badly damaged those countries, particularly the United States and the United Kingdom, that have wholeheartedly supported Israel throughout this. When South Africa issued its application at the end of December, the reaction by Secretary of State Anthony Blinken was that it was meritless and it distracts the world. Rishi Sunak, the British Prime Minister, stated that the application of South Africa was completely unjustified and wrong. And we should remind all of us that back in around November 10th, 3 months ago, Secretary of State Blinken had said there are far too many Palestinian civilians have been killed. And that was at a time when there were only 11,000 deaths in Gaza. We are now, as I said, at 28,000 and likely much higher than that with respect to those who are unaccounted for. The big problem with respect to the ruling of the court is that the ICJ has no police, it has no army to be able to enforce its orders. That has to happen if the losing party does not wind up obeying the orders issued. We go back to the United Nations Security Council. We know that already there have been 3 resolutions that have been proposed by the Security Council calling for an immediate ceasefire. The most recent was voted on the 22nd of December, and all 3 of those resolutions were vetoed by the United States, a permanent member. When on the 22nd of December, with the most recent resolution being vetoed, the vote was 13 members of the Security Council in favor of the resolution, 1 abstaining, the United Kingdom, and the United States opposing it. Presently, Algeria has a draft resolution calling for an immediate ceasefire based on its interpretation of the ICJ ruling, which is mentioned specifically in the draft resolution that is circulating. Will the United States wind up vetoing a resolution now for the 4th time in these circumstances? This ruling, I think, and the drama around the arguments being made last month and then when the ruling came out, really show, I think, a fissure point between the global north and the global south. And the South Africa has really punched above its weight with respect to bringing this kind of application and speaking upon the vast majority of public opinion around the world. I just want to end my presentation by quoting a prominent South African constitutional lawyer, Dan Mafori, who was quoted last week in the New York Times as saying this: "As long as those who make rules enforce them against others while believing that they and their allies are above these rules, the international governance system is in trouble. We say these rules are the rules when Russia invades Ukraine or when the Rohingya are being massacred by Myanmar. But when it's now Israel butchering Palestinians, depriving them of food, displacing them en masse, then the rules don't apply, and whoever tries to apply them is anti-Semitic. This is really putting these rules in jeopardy." I wholeheartedly echo what the High Commissioner has said with respect to this really putting a test to the international legal order that we have, and that we can't have a menu a la carte when it comes to obeying international law. The rule of law applies to all with one single measuring stick. Thank you.
Thank you so much. Much appreciated, especially more of those details on the tactical sort of framing of the case and how that responds so clearly to what's happening and why those choices were made in that way. Thank you so much. For our final panelist, I'm excited to introduce Dr. Katherine Nastovski today. She's an assistant professor in work and labor studies in the Department of Social Science at York University. Her research focuses on struggles for workers' justice, labor transnationalism, and the relevance of colonialism, imperialism, and racism for thinking about workers' organizing. As a former union activist and international labor solidarity organizer, Dr. Nastovski's community-engaged research agenda aims to build the field of global labor studies in Canada in ways that support the efforts of labor organizers and activists. So thank you so much for taking the time to speak with us today.
Great, thanks so much, Greer. Thanks to the other organizers. I think the fact that there is a committee and in CAPE speaks to just the explosive, new organizing that's happening around this. And I think, what Mo and Michael have already pointed to in terms of the limitations of the law, and workers are recognizing that and taking up actions and focusing on, stopping the arms trade and other things. Because we've seen such limitations in the political and the legal spheres. And so this brings us to the role of labor and the place, the potential for this growing movement, and what some reflections that I was asked to share about some of the similarities and differences with the campaign around South African apartheid in the labor movement in Canada, which was arguably one of the largest campaigns globally, and reaching hundreds, if not thousands, of members at its height each year, talking about apartheid and mobilizing and asking workers to engage in direct action in the workplace and in their communities. So this first slide that I have up here, underscores some of the differences. These are parallel struggles happening starting in 1948. And have been taken up in vastly different ways and have very different labor contexts. In the case of South Africa, labor was a critical piece of bringing down the apartheid regime along with the other strategies, including armed struggle. Whereas in Palestine, we see here, the marginalization of labor, as apartheid was built and continues to be. So seeing the UN truck there and the reliance on aid for so many unemployed workers in Palestine. For more on that, I have a link to a book on labor in Palestine, and for those of you who are interested in thinking about some of the complexities of this issue. Okay, so these are happening at the same time. And while the Canadian government likes to take credit for its moral superiority in the adoption of sanctions against South Africa in the 1980s, really labor and student movements and community movements and religious movements were critical. Civil society then as now play a crucial role and have to play a role. So some basics in terms of what happened in the South African case. The work inside labor was mostly, although the Canadian Labour Congress and its predecessors had positions against apartheid right from the beginning, on paper at least, there was really very little activity around South Africa until 1980, when the SACTU Solidarity Committee was formed. So this was, SACTU was a union that was banned in South Africa in the 1950s and was part of the Congress Alliance and part of the liberation struggle. And so members of this committee was formed amongst mostly 4 people based in Toronto who had, really built this amazing movement. Eventually, there was also a committee in Vancouver and some folks organizing in Montreal. And those links that I have there, and I'll post them in the Q&A, I think it's better for you all to actually hear from the organizers themselves. And they've been doing a great job at archiving their experiences and, all the different strategic lessons that we can learn from that. I also think this might be something that we host as a standalone Labor for Palestine event with some of the organizers to dig a little bit deeper into some of the strategic lessons we can gain from that, from their work. So the SAC2 Solidarity Committee was critical for Labor for Palestine from its inception, and Labor for Palestine really looked to the SAC2 Solidarity Committee as a model for how to organize, and there have been various other types of models that existed. Some of the key features that they drew from has been the focus on rank and file education and mobilization. So, and even where, you go higher up in the union, spaces get shut down. It was really about learning how to make and take space inside unions. Another key piece of this lesson is, go to where workers are at. While some workers are already involved in various struggles in their communities, it's challenging to get them to go to events outside of their workplaces or existing union spaces. So it's really about finding the spaces inside our unions and building that within. This means mapping out union spaces, finding them, and finding ways around it when you get shut down, which inevitably happened in the South African case and is even more of an issue in the case of Palestine. And so in the early days of Labor for Palestine, that meant, seeking out institutional spaces inside CUPE, or some of the locals inside CUPE, one of the national events, or the postal workers when it was support for larger Federation and Congress events. So having some institutional basis in particular unions is important. In the case of the South African struggle, that was really the United Auto Workers and also the postal workers. So those were the postal workers provided the group with office space. And so that was critical for their work. And even today, if you see up on this on the slides here, there was a book that the committee produced called Trafficking in Apartheid, which really laid out all of the links between race and class, colonialism, and Canadian involvement in apartheid. And just, before this the current genocide that's unfolding began, the research committee of Labor for Palestine was drawing from this specific handbook to actually model a new one for what we're looking at for research on how unions can strategically outline, or how we can outline pensions, other types of connections we have with Israeli apartheid. And finally, worker direct action. One of the most significant pieces of the SAC2 work was direct action in the workplace, really focusing on the power that workers have in their workplaces. And so the picture here is of dock work, Block the Boat in 1986 as part of the SAC2 Solidarity Committee's Week of Action, which also involved postal workers refusing to process mail, airline workers refusing to process tickets, and so forth across the country. So the level of work and activity that we see now around Israeli apartheid definitely could not have happened in the 1980s when the South African work was happening. And part of that has to do with the deep historical commitment to Zionism within the Canadian labor movement. And that was very much constrained any kind of solidarity in the 1980s. And it has, led to this being very slow in developing. And so some of this, it meant that, labor was involved in pushing for the recognition of the state of Israel, and also part of supporting financially and politically, the settlement, basically, in various kinds of ways. And I can take this up more in questions. And so the institutional landscape was really, in terms of Zionism, was really centered around the Canadian Association for Labor Israel. There was a US branch, and this Canadian branch really was focused on a campaign to support the Histadrut, which is widely known as the Israeli labor movement. However, it is actually a pre-state, historically was set up in 1920 as a pre-state colonial engine. Basically, it had its own army. It had, provided health and medical support for settlers so that they would settle, and had its own companies to actually, create infrastructure in Israel and create jobs. So it had, the business side, a union labor side, and a military wing. And so it was really, that is an important piece for us to consider, especially as, the Histadrut has historically been an honorable guest to most Canadian Labour Congress conventions, alongside the AFL-CIO and the British TUC. So it's been very much at the core, trade union partner globally, and also globally. Okay, so in terms of the Canadian Association for Labor Israel, what did they do? They were really involved in, they would have annual dinners honoring trade union leaders. So most trade union leaders were honored at some point in these dinners. And these dinners were fundraising for money to be sent to Israel for two areas: one, setting up health clinics, and the other, vocational schools that were sponsored by the Canadian Labor Movement. They also engaged in regular trips to Israel. So they would pay for the flights, and then when they got there, the Histadrut would tour them around, the Canadian labor leaders around Israel. Here we have a seminar in Muskoka that was, had Tommy Douglas, the, executive members, OFL president, VPs of the CLC, the Israeli labor attaché to the US, presidents of various unions, including the fur workers, the amalgamated clothing workers, and the International Ladies Garment Workers Union presidents, talking about how to support, how to better support Israel. So this doesn't really break until 1988 with the first Intifada. And this was really, at this point, there was some, a bit of a shift, a bit of an opening that started. Another issue at that point, right after, was in 1990, this whole infrastructure with the Canadian Association of Labor Israel began to decline. They really scaled back. They had offices in Vancouver, Winnipeg, Toronto, Ottawa, and Montreal to build all of this work with lots of staff, et cetera. And they scaled back to 2 offices in Toronto and Montreal. And so there was a shift in focus away from labor. That didn't mean that there were still tours to Israel and so forth, but it had really minimized by this time. Okay. And in terms of some of the politics behind this as well, there were also, aside from the actual organizing and the infrastructure, which was tremendous inside the labor movement, coming both from inside the labor movement and external forces, there was also this connection that continued this relationship, which was around social democracy and settler colonial logic. So we can see this in this quote here. It sounds like, Selena Robinson could have written it last week, very much, pointing to, terra nullius thesis here, and really connecting the way in which there's a connection between Canadian unions and Israeli unions as as pioneers, and really building up this space. So the History Druid and CLC were similarly positioned vis-a-vis liberation struggles, and really worked to win over the labor movements at the heart of anti-colonial struggles to the possibilities of workers' justice within a social democratic state. So here we have the Afro-Asian Institute in Israel, where they would bring in trade unionists from all different places in the global South, extolling the virtues of a kind of social democratic model of trade unionism. And the Canadian labor movement was involved in similar things in places like the Caribbean. I can answer more of this later in questions if people would like. One of the reasons why I raise this issue is because it speaks to the problem of this vision of socialism that was put forward for many decades, an idea of a socialism for settlers only, and a vision that socialism could be still based on colonization and displacement of the Indigenous population, that this was perfectly acceptable and not in fact any kind of contradiction. So things really shift with the BDS call from Palestine in 2005. And so there were, before this, in this interim between the 90s and 2005, there were various types of resolutions, mostly two-state solution, adherence to, UN resolutions of various kinds. But the shift really happens with the BDS call. And so, and while comparisons had been made prior, so in Durban, the World Conference Against Racism in 2001, understanding Israel as an apartheid system, it didn't really gain currency until after the BDS call in 2005. And an important piece of that is that workers really got this. This really shifted the discussion, an analysis that worked, changing this from a question of a religious battle that's too complicated for anyone to understand and therefore should not speak about, to an understanding of this history as ongoing colonialism and racism and rooted in those. And so the threat of this shift in the narrative was apparent in the force with which it was opposed. So in the Canadian context, when QP Ontario passed its BDS resolution in 2006, there were months of very intense backlash that only quieted after, Israel started bombing Lebanon and Gaza that summer. And so, as continues to be the response, the backlash is centered on three main claims. One, that critiques of Israeli state actions are anti-Semitic. And the desperation to hold on to this weapon is definitely seen in the efforts of the International Holocaust Remembrance Alliance to define anti-Semitism, or to, conflate critiques of Israel with anti-Semitism. And this is a huge piece that we have to contend with. Two, why are unions, the question of why unions are involved in anything beyond bargaining and servicing, okay? That's another one that is critical, and we hear this from members. And three, why single out Israel? Why Israel and not other contexts? And so activists inside Labor for Palestine, Independent Jewish Voices, ARC, and other organizations continue to challenge these claims. But it means that the level of backlash, which is different than the South African case, it's not that there wasn't backlash. And the link here that I have from Michael Buchert, compares the backlash in both cases. But the extent to the backlash is on a completely different level. And what that means for us when we think about doing this work in our unions is that a lot of time gets spent, time and energy gets spent in defense work. And so that needs to be considered in our work and how members, how activists get mentored and trained also in terms of doing defense work as well. And it means it is harder to make and take space necessary in our unions to do rank and file education and mobilizing work because the backlash is more significant. And And but on the flip side, it was the backlash that actually led to the formation of Labor for Palestine, and 2 years later, Independent Jewish Voices. It was this extensive backlash that prompted people to actually develop a strong organizational basis. And so there is that other piece, and we're seeing that today in terms of Israeli actions, but also then responses to backlash have further brought people into the movement, and we're seeing the extent of this. Okay, and finally, a deeper problem, which is the state of unions themselves. So when the South African work was happening, it was a very different political context, ideological context within unions than what we're facing today. Now, in that time and today, we deal with opportunist leadership, conservative unions. This is always there. They were there in the 80s. They're there now. And for leadership today, Palestine, there's much more of a liability than South Africa because of the level of backlash. And so in 2006, when it was extremely lucky that the BDS resolution that Sid Ryan actually allowed it to be debated in the convention. Many other union leaders would have blocked it from hitting the floor. And so that was definitely an important opening. And so it's not that leadership should be completely ignored, but the importance here, I think, is the emphasis that the SAC2 Solidarity Committee had on, really not focusing on leadership and courting leadership, but getting workers to actually take action and take action themselves and to focus on building that. So in the context of the 1980s, there was a huge generation of new left organizing, feminist, LGBT struggles, also other kinds of international solidarity work around Central American struggles, and clear connections for many trade unionists between imperialism, work, and the role of militarism, which we don't necessarily have today. And so organizers were not dealing directly with what is the dominant conception of unions as a kind of servicing body or an army of technicians or lawyers. And so as someone involved in labor education myself, I've witnessed this, how challenging it is for union members to make sense of why we engage in international solidarity work at all, never mind Palestine specifically. And so this presents a problem strategically for supporting worker self-activity. In unions with a culture of history of direct action, this is a non-issue. So I remember being in Port Elgin, and CUPW members, because of that history, knew right away how they started mapping their workplace and thinking about how to use their actual power in the workplace to be in solidarity. Okay, but that is an exception. The culture of organizing, this kind of culture of organizing does not exist in most unions. And in many unions, there has been nowhere for workers to actually cut their teeth. Hence why I raise this issue of strikes. Many workers have never been involved in strike action or any significant mobilization. And so many will not necessarily know, how do I actually take action in solidarity with Palestinians against Israeli apartheid. And so this means a shift in how workers understand unions, their role, and also understanding of where workers' power lies. And, this has other implications. We are living in fascist times. This is, highlighted by the fact that the ceasefire demand is seen as somehow radical, and accepting the idea of the union as having value as merely a servicing body with courts as their forums as a path to workers' justice just does not serve workers. And so in part of the work to support this worker self-activity, we have another layer to work through, which is actually using this work to actually be a site for skill building and for workers to cut their teeth in actual mobilization. And so I think that needs to be thought through in our strategies. and how and where we want to engage and put our time. Hence, the importance of education work as well. So I'll stop there. I hope that was useful for folks, and please ask me more questions in the Q&A.
Thank you so much. Thank you. Yeah, and just those connections between what we've seen before, what we're seeing now, and starting to put our minds towards what we can expect moving forward is going to be so important for continued organizing. I'm looking at the time, so I'm just going to jump right into some questions here. I'm going to start with one for everyone. It's focused a little bit on the ICJ. I know, High Commissioner, you spoke a little bit about what other steps South Africa is taking in this process, but we've had a few questions around just what happens if Israel refuses to comply, and what the next step would be on that front within the international legal arena.
Well, that's a good question. Am I muted?
Yes.
Can you hear me? So, as I said in my opening remarks, that today we have lodged our next request to get the court to make a ruling that would prevent Israel from further destruction of Rafah. We think that's important, and we believe that the court has the authority to do such, to give a further injunction in light of the impunity of Israel. So I honestly believe that the ruling of the court is something no country can avoid, because the court has made that ruling. I think increasingly Israel will find itself isolated in respect of that, and we will continue our actions within the legal means, and we will demand that the Security Council also addresses the finding of the court. We are aware that the USA and others may attempt to veto whatever discussion on the matter, but I think the ground is shifting in respect of even the critical voices within the United States, within the administration, that is saying enough is enough, and Israel must be brought to within the bounds of international law. And I think that is what is at stake here: international law and the right for states to act with impunity in violation of international law. And I think no country, and I don't think even Canada, can escape that by its silence. It would have to speak out against the violation of international law if Canada is going to be taken to be a respectable voice in global affairs. If it refuses to speak on this matter, then we will refuse to listen on other matters. That, I think, is the situation. I'm sorry for being less polite, but I think the situation has now demanded that we move beyond politeness and deal with the requirement of the law in the cold face of the law. Thank you.
Could I just add to that? When the ruling came out on three Fridays ago, on the 26th of January, Canada issued a statement a couple hours later, late in the day, on a Friday afternoon, to say that it recognizes the role and importance of the International Court of Justice, but it went on to say we do not that our respect for the ICJ does not mean that we accept the premise of South Africa's case. This is not a final ruling, and that we will pay attention when the final ruling takes place years from now. If I can just contrast that with what Canada has said over the last 2 years on 3 different occasions with respect to other rulings on provisional measures coming from the International Court of Justice. With respect to Myanmar, in August of 2022, Canada joined a number of other countries, including the US, the European, the UK, and the European Union, which said after the ICJ had issued provisional measures with respect to Myanmar and the allegation of genocide regarding the Rohingya people, it said, We reiterate that Myanmar must comply with the ICJ's Provisional Measures Order. Again, 2 years ago, in May of 2022, with respect to the case brought by the Ukraine against Russia, also with respect to genocide, Canada joined the US, the UK, the EU, among other countries, and said, we welcome the court's ruling for provisional measures and strongly urge Russia to comply with this legally binding order. The ICJ is a pillar of the rules-based international order. And then in this past November, 3 months ago, with respect to a ruling made by the ICJ on a case against Syria with respecting its use of torture, Canada plus the Netherlands said, we welcome this decision of the court to indicate provisional measures. The order issued today is binding on Syria. It must now immediately implement these provisional measures. Yet when it comes to exactly the same order with respect to Israel, Canada is putting an extraordinary amount of daylight between it and the provisional measures ordered by the court with respect to Israel's military operations in Gaza. I'm sure that's not hypocrisy. I'm sure that's got nothing to do with the double standards on how Canada views the operation of law in the international community.
Thank you. And I'm not sure, Dr. Nastovski, if you'd like to weigh in a little bit, or. You're good.
Yeah.
No problem. Building on that, we've had a few questions around exactly that, Canada's legal obligations and what they are for the Canadian government in light of this ruling. We've had a lot of questions around, the ways in which the Canadian government can continue to ignore international agreements regarding, arms and aid, and what can citizens do from a legal perspective to take action against this for their complicity in genocide.
Let me try to start with that. It is true that Canada provides military assistance to Israel through the sale by private companies, but which have to be approved by the government. And the latest figures, as I understand them, there was a significant jump in the value of military goods being sold by Canada to Israel towards the very end of this year, obviously covering the period of time when Israel's military operations were being conducted in Gaza. The warning, and this is echoed by the High Commissioner in his opening remarks with respect to genocide, is not only does a genocide ruling apply to Israel, because the Genocide Convention goes to the crime of crimes, the responsibility of every country, the 153 countries who are signatories to the Genocide Convention, means that we all have a duty, all countries and states have a duty to prevent genocide wherever it might be occurring, and not simply to say long after the fact, oh, genocide did occur, maybe we should do something now. The obligation is to take immediate and responsible action while the genocide may be in the making. We've already been given by the warning with respect to this almost 3 weeks ago by the International Court of Justice. We should be operating with all four engines with respect to reviewing our relationships with Israel. Instead, our attention got entirely sidelined by the allegations with respect to UNRWA on the very same day that the ICJ ruling came out. It's astonishing to me that Canada, a longtime backer and funder of the United Nations Relief and Works Agency for Palestinian refugees in the Near East, would wind up suspending its funding on the mere allegation given by Israel that 12 employees of the 13,000 UNRWA employees working in Gaza were complicit in the atrocities of October 7th. And that was without any evidence being shown to them by Israel. And I understand no evidence has been shown up until this day. And yet we have plausible case of genocide. I've not heard Canada saying in response to that, using the same measuring stick, that it's now reviewing its diplomatic relations with Israel. It is now reviewing it with a view to halting its military weapons sales to Israel, or it's reviewing its trade relationship and free trade agreement with Israel because of the finding of a plausible case of genocide with respect to Israel. It's astonishing to me that we operate with such different measuring sticks on an issue of vital importance to the international community.
And if Canada continues to not comply, are there any things that will happen about that? I mean, punishment is a bit of a strong word, I think, but certainly anything like that.
Sure. Look, Article 3 of the 1948 Genocide Convention outlaws or prohibits complicity in genocide. Complicity in genocide is a very broad term. It's all that it says. It just uses those three words, complicity in genocide. So that could mean not only actions in support of Israel's operations by Israel's political or military or administrative leaders. It could mean complicity in genocide by other states as well. And certainly that's an issue I think that would be facing many countries in the global north, first and foremost the United States, but certainly Canada as well. We now have warning. We now have a clear signal from the highest court in the international system with regards to this. What that would probably mean, in answer to your question, Gear, is whether or not there could be a case to be brought in the Canadian courts based obviously on international law and the fact that Canada is a signatory to the Genocide Convention, to compel Canada to, I suppose, at the very first step, to review and end its military sales to Israel with respect to that, but also perhaps to review in a broader way any other part of our relationships with Israel that may be contributing to and therefore complicit in the plausible case of genocide with respect to Gaza.
Thank you. That's very useful. We have a question here about the call for the ceasefire and what it would look like or could look like to shift away from that. A lot of the discourse up until this point has been around making those calls for ceasefire and ending apartheid within this colonial context. But what could it look like to shift into more active support for Palestinian resistance, liberation, and decolonization, particularly when our own colonial institutions continue to frame the Palestinian resistance as terrorism, and I'm sure there are lots of I mean, it's a different circumstance in South Africa, but certainly that bigger shift that needs to happen. Any insights into that?
It'll be helpful to remember, as Katherine did in respect of the SACTU labor movement, that the liberation movement in South Africa, and particularly the ANC, for which Nelson Mandela was its president, was also labeled as a terrorist organization, both in South Africa and by other countries. And as a result, many ANC members could not receive visas to come into Canada. And it may surprise you that many ANC members still today have difficulty in getting visas to come into South Africa, to Canada. But that's a separate matter. So the notion of terrorism, and I think we can agree that yes, there are terroristic activities that must be punished, and the atrocities that happen, there's a forum in which it must be dealt with in respect of the International Criminal Court. But I would really caution the world getting stuck in the use of terrorism to exclude voices, because at the end of the day, we can all agree that the sustainable resolution to the problem of Israel and Palestine is going to be negotiations. There is no other way. You're either going to have a complete genocide of people, complete extermination of people, or a settlement of people through dialogue and discussion. So I would just caution that, to find a solution to the problem of negotiations, if you get too stuck in the labeling, then you will not be able to allow yourself to negotiate. And God forbid if Israel should take a law out that says they cannot negotiate with terrorist organization, well, then we are in a forever war in regard to the Israel-Palestinian matter. So I would really caution that, the world should stop using labels, deal with the source of the problem. The problem did not occur on the 7th of October only. There was 75 years of occupation, and that matter needs to be resolved, and it should be resolved peacefully and through negotiations. Why do we want a ceasefire? Well, because we want the killings to stop. We want the suffering to stop. We want humanitarian aid to come in. And then we want to allow, based on the peace that will come through a ceasefire, for other voices to be able to discuss a sustainable future for the people of Palestine and Israel. Now, let me just say, there is a matter there. Liberation is not only for oppressed people. Liberation is also for the oppressor, from the freedom to oppress. And we have seen this in South Africa, that white compatriots who were forced through conscription into armies and to military activities suffered an enormous amount of trauma as a result of them having to do what their governments were forcing them to do in the defense of apartheid. And this is something that we must not lose sight of, that liberation and a sustainable solution to the problems of Israel and Palestine frees the Israelis from their own obligation to oppress. And we must not undervalue that enormity of an effort. Thank you.
Thank you. I'm just looking at the time, so I'm not sure. I'd like to just let everyone have a final comment if they would like, and then we can wrap things up.
Let me begin. I'll be very, very brief. I'm old enough to remember, and a part of the labor movement in the 1980s and the 1990s, to remember solidarity work with respect to South Africa, to remember solidarity work with respect to Central America, and particularly with respect to El Salvador and Nicaragua. And I knew how important that was with respect to, if you like, spreading the democratic ethos that unions are so tied to, and raising voices that we're able to combine with other interested organizations such as faith-based organizations in Canada. And it did make a real difference in terms of changing the needle of Canadian public opinion, and more importantly, with respect to the government response in the 1980s and 1990s to issues with respect to South Africa. I know that Glory sometimes points the spotlight in Canada on Brian Mulroney. That only happened because grassroots organizations, beginning with unions and churches and other solidarity organizations, made the difference and entered into the conversation uninvited and pushed the needle forward.
Yeah, that's that is absolutely correct. The South African and our liberation is a huge beneficiary, mainly of the action of labor movements in Canada. It came at an incredible time of human solidarity. We are highly appreciative of that. And I think it is the voice of civil society must rise again. And yes, it must do so on the matter of Palestine, absolutely correct. But it's to do so in a range of other issues. We've been asleep for far too long. And I think it's time that we awaken to human consciousness and to do everything within our power as civil society to create a better world, just a better world for everybody. So that will be my last comment. Thank you.
Okay, I just want to say just how impressed I am with the level of activity that workers are engaging in. It's amazing. And just to say as well, you know, I kind of scratched the surface of, you know, the comparisons and what we can draw from these comparisons. I do think it would be nice, and I'm happy to work on this too, is, you know, having a Labor for Palestine workshop. There are folks on this webinar who are involved, who were the key organizers. I saw Jane, Brenda, a few others who were key organizers from the SAC2 Solidarity Committee. We should have a workshop. We've had, you know, Labor for Palestine has had long, close relationships with folks. Let's have that. Let's bring these things together to help people think through how to do their work in their unions or in their city L4Ps. So that's all.
Great. Thank you so much. And thank you so much to everyone today on behalf of ACEP-CAPE for Palestine and also Labor for Palestine National. We're just so grateful for everything that you've shared with us. These insights are so critical to ensuring that our organizing and solidarity efforts are as lasting as they are cunning and grounded in deeper, more critical understandings of these legal tools and the implications and knowing clearly what this means or doesn't mean for us as labor. So a reminder to everyone to follow our esteemed panelists on their social media to read and support their incredible work. We've got lots of questions about how to access some of the resources that have been shared today. So we're going to do our best to make that happen. In particular, if you are an ACEP-CAPE member, do reach out to our group, especially on Instagram. There we'll also try to link to a lot of these resources as well. And I would really encourage everyone to find their local Labor for Palestine chapter to stay in the loop on any actions, events, rallies, and meetings and things in your area. Hopefully you feel inspired from this conversation today and want to get active. As well, there were several questions as well around arms embargo. So there's lots of information on that on the website, Labor for Palestine. And also there's a petition going around by Canadians for Justice and Peace in the Middle East. So thank you so much, everyone. Thank you, High Commissioner Shaik. Thank you, Professor Lynk. And thank you, Dr. Nastovski, for everything today. Wonderful. Have a great afternoon, everyone.
Bye-bye, everyone. Thank you for listening. Bye.